Okay, once again, welcome to Lawxpertsmv India. We will start today's class. Hope I'm audible. Let you come out. Yeah, if I'm not audible, kindly let me know immediately. Okay, and if the screen is not visible also, kindly let me know immediately. So we are going to start the second topic in law of crimes, IPC and BNS. So the first thing I would request is that class would be entertaining only when you discuss with me. Okay, if I am the only person who is going to keep on talking, that will be boring for both of us. Okay, and you are not aspiring for a normal examination. It is a UPSC examination. How do you think you can be a better civil servant if you're not open for discussions? Right. So do discuss with me. Wherever you get a doubt, please do feel free to stop me, clarify your doubt. Okay. So we'll go to today's class. Let me share the screen. Okay. In last class, one of the students has told me that they see a gray colored bar on the screen and it is hiding all the notes and you're not able to follow the class. So is the gray color bar still appearing on the screen for you?
No, ma'am.
Let me know.
No.
No, right? It's not right there. Okay. 1 second. Let me change the resolution. Yes. Okay. We are all set for today's class. Today we are going to see an interesting class. It's not just concept. We are going to rationalize things because in UPSC, it's not that you give only the concepts. In our college semesters, what we will do, any question they ask, we will write the relevant section. What are the ingredients? As much as possible, we will write the case laws, or we will also make up the case laws with the names we know, right? But UPSC is not like that. Every concept, you have to append the concept. That is, you have to understand the concept by some example or illustration or some case law you have to give or some current affairs you link, and make sure that you are able to link the concept with all the relevant practical things. Why do we have law? Why do we have all these concepts? Only to be applied practically. So as a civil servant, UPSC will expect you to write an answer that is not bookish, but you are able to relate the concepts with the every detail that is happening in a real life scenario. Okay. Now we will go ahead. If I'm too fast also, you can let me know. So we are studying law of crimes. IPC and BNS is the perfect one. You cannot say IPC is dead and completely we should learn only BNS. Why we cannot say so? Tell me, can we avoid IPC altogether and read only BNS? Can we do that? Will that be right? Nobody wants to answer.
No, maybe sections may be changed. The core concept is the same for everything.
Karthik sir, I cannot get you. You are saying that the sections are same.
Sections are always changing now. Therefore, IPC, CRVP can be the core concept is same in every.
Actually, when we take a lot of cases, if the FIR is registered under IPC offenses, they can be tried only under IPC. Only after the new law comes in, if the FIR is registered under BNS will apply. So for the next 20 years, even the old cases are going to run in the court, right? So we have to read IPC and BNS together only. That is the reason. Okay. Now, why do we need an IPC or BNS? What is the aim of this criminal law, first of all? Why do we need them?
Abolish the age-old British laws.
Abolish. IPC itself is a colonial law. What is the aim of IPC itself? I'm asking. Why do we need these laws? What is the idea of these laws?
To regulate law and order.
To regulate law and order. Good. How do we do that? The answer is very simple. Simple thing. How do you regulate law and order? Nobody else wants to talk. Everybody wants to stay silent. The main aim is to punish the offender, right? So you say these are the offenses. Yes, there is theft. You do these things, it is criminal trespass. You do all these things, it is murder. It is culpable homicide. All the names you give. And if you don't give the punishment, what will happen? What is the use of making all these categories of offenses? So the entire aim of IPC and BNS is to give the punishment. Okay. So today we are going to deal about this punishment, but how we are going to read is that what we are going to cover, we have to cover from the previous year questions. So what are the areas mostly related to the question? That is what is very, very important. We are going to see the other areas as well, but these are the areas that we will be concentrating. So coming to the PYQs, previous year questions, if you see, these are the areas that they are concentrating always repeating the same thing. So first they are asking about kinds of punishment. What are the types of punishments available? Okay. Next, what is the philosophy behind these punishment? So we will call these philosophies as theories of punishment. So once again, let me tell you, during the class, don't try to take the notes. If you are able to understand the class, that is much enough. Okay. So try to understand the class now. Don't take the notes. Later point of time, I'll share the PDF to you. You can take conveniently. So next we are going to death penalty. Death penalty is very famous. They are not going to be quiet unless and until we abolish death penalty. But abolishing death penalty, I am not a good fan of abolishing it. I think we need to have more strict laws like Arabic countries. Okay. But this is an important area for UPSC. Kinds of punishment, philosophies for this punishment, and finally, the biggest debated area, death penalty. Okay. So we will go into the concepts now. Nandita, have I toned down or it is still faster? You
No,
can
ma'am,
tell
it's
me.
fine. It's fine.
It's fine, right? Okay.
Okay.
So let's come to the real life scenario. If someone is hitting you, okay, they are hitting you like this, chop, they are giving you on your, giving a tight slap. What you will do? Each person must give an answer. One person give an answer. First, what Nandita will do? Someone is slapping you for no reason, no way related to you. Suddenly you go there, she's coming and slapping you, giving a tight slap. What you will do?
Go and file an FIR.
Go and file an FIR. See how lawful you are. So sweet of you. Okay, she'll go and file an FIR, it seems. Okay, what Karthik will do?
Ma'am, tit for tat.
Tit for
Tit
tat.
for tat.
Well, what you will do exactly, you tell me.
So I'll try to beat or
You will give another slap with
yes,
all
ma'am.
the power, right? Chop, you have it now, like that. Okay.
Just action itself.
Okay, very good. Okay. Now, then what HP will do? I don't know who is this HP, but if you put your name, that would be great because I'm not seeing your face, right? At least I know your name. So who's this HP? Would like to answer? HP, HP. Anyone else? Anyone else? Suresh, Saumya, Bala. Bala is there? SD was answering good. No one would like to answer. Okay, why like this? So next time I'm going to ask the admin to remove the people who are not answering because I don't know whether you are listening or what. Okay, so we got two answers. What happened? Who is trying to answer? You can raise your hand or tell me. All right. Maybe there is some connectivity issue. Okay, we'll go ahead. So first one, Nandita wants a lawful relief and Karthik wants tit for tat. So you see, some people will hit back, some people will do something else. So the mode of punishment, why do we punish? That reason is the theories of punishment. Yes, for a wrong, we need punishment. There is no doubt in that. But why do we punish this person? That differs from one thinker to other. That differs from one person to other. I will punish for certain offenses because it should not happen to some other people. See, if I stay quiet, then you will victimize another person. So you should be deterred. So for what reason you are giving punishment? Why you are giving punishment? If you ask this question, there will be a lot of reasons. And that reason is called as what? Theories of punishment. So these theories of punishment are repeatedly asked in previous year question. So we must master it. Okay. Now we have all these theories. You ask why? We have got lots of theories now. That is the answer. Deterrent theory, retributive theory, preventive theory, reformative one, and expiatory one, which I feel is the most funniest theory of all, expiatory theory. Okay. So if a question is asked in theory basis, see, if a legal question is asked, what you can do is you will give the section, you will give the ingredients, and you will give a conclusion, case laws, and all, you can fill it up. But question comes in a theory, that is legal philosophy, it becomes little difficult because you try to put the same line again and again in a different form. So your content will not be clear. We have to be very, very careful when we are dealing with theory. So one hint what I will say is try to bifurcate your answer with side headings. So you give the proper points. So how you can give the side headings, that we are going to see now along with the concept of the theories. Okay. So now we will go to the concept of the theory. First one is the deterrent theory. So what is the aim of this theory? It is to prevent others from committing the crime. So the idea of the theory is, it is not that you commit a crime, you must be penalized. Nothing like that. You have committed a crime, I will give you such punishment for you. So others will not do the same. This happens at home. So see, if your brother or someone, when we are very small, if your sibling as well as you does not take any food or something, you do something wrong together, what your mother will do? They will come and hit the first sibling, give a tight slap or scold the first sibling. We will be seeing that. On seeing that, the second sibling will be quiet. So that's what is deterrent theory. As the name goes, I will give such a punishment. I will give an example. I'll make you an example that others will be quiet. Okay. So what is the aim? Like this, you have to write in the answer. First, the topic of the theory, and then you have to give what is the aim of the theory. It is to prevent others from committing the crime. So how do you do that? How do you implement this aim? The method is prevention is done by exemplary punishment. So the person who has committed the offense, I will make this person as an example for others. So if you do this punishment, I will give you a if you do this offense, I will give you a very big punishment. So others are going to see you and they are going to keep quiet. Okay, that is the idea of deterrent theory. So what is the core concept that is used here? The idea is fear, right? If our sibling gets scolded, why we are keeping quiet? Because we fear our parents. A fear is created. So we will also be scolded. We will also be punished. So we have to be quiet. So the core concept of deterrent theory is playing on fear psychology. So that is very important. So you have to mention that as well. So can you give me any examples of deterrent theory? Any example? We do have in India as well. No idea of deterrent theory. What? All keep quiet. You're not able to understand what is deterrent theory then? Not able to understand? Shall I repeat? Okay, unless and until you answer, I'm not going to continue. What, Mr. Karthik, you're not able to understand the concept of deterrent theory?
No, understand, ma'am. I can't able to create an example.
No. Any example? Okay, we go to Arabic countries. You see, if anyone commits an offense with any of their body part, that body part will be mutilated. You take someone else's property with your hand, that hand will be mutilated, chopped off. Okay. And if you commit rape, that particular part will be chopped off. Okay. On seeing that, anyone else will come and do the same thing? No, they won't do it. It creates a lot of deterrence. So best example is Arabic countries, where is mutilation of parts. Mutilation means cutting down that particular human part which is used for the offense. Okay, so that. Talk about India in rape cases, we do give death penalty. So death penalty is an example, severe punishment where others won't do the same thing. Okay, so that is also a good example of deterrent theory. But what is the criticism of this theory is that there are a lot of hardcore criminals. They know that if we do these things, they are going to give this particular punishment. They know everything and still they do the same thing. Okay, we do have such criminals. I see people coming for remands and all, right? They know that for murder, they are going to be kept inside for remand for these many days. So they'll be coming happily, get remanded, go to jail happily. So they are hardcore criminals. They cannot be shaken at all. Whatever punishment you do, I'll be happy only. Okay, you put me in jail, I'll be happy only. There'll be such sort of people. Their mentality is like that. So whether deterrent theory can stop them? No, because they are hardcore criminals, they have no fear at all. We need fear. From there only deterrence comes in. So when there is no fear at all, deterrent theory will not work. So this is the biggest criticism of deterrent theory. And the thinker of deterrent theory is Locke. Okay. So he gives this statement, every commission of an offense should be made a bad bargain for the offenders. So bad bargain here means a bad example. So if someone commits an offense, he must be made as an example for others. Okay, not in a good way, but in a bad way. So coming once again to the deterrent theory, the aim is to prevent others, deter others from doing the same crime. How do we do it? We give stricter exemplary punishment. So we play on what? We play on fear. So we give the fear so that they don't do it. Best example is Arabic countries where they will mutilate the body parts. So what is the criticism? Certain people are very hardcore criminals. Whatever you do, they are not going to do anything because they don't have fear. For them, deterrent theory will not work. Even in our home, there will be some siblings. I had my brothers who will get the kickings and they will do the same thing again. Every time we get the report card, if we don't get good marks, we're going to get kickings. You may not heard of, but as 90s kid, we do get beaten up with all spatulas and also with belt. Okay, that is very, very famous. So we'll get the kickings again and we will do the same thing. Like that, hardcore criminals will be there where they don't have any fear and they will do the same thing repeatedly. For them, deterrent theory will not work. Now you can ask me what theory will work for them. We have multiple methods that we will see in the upcoming theories. So any doubt in deterring theory? If you don't have doubts, you can let me know also. Any doubts? Deterrent theory? No doubt? We'll go ahead. Okay. So now we are going to retributive theory. So we will rename this as Karthik sir's theory. He only told that tit for tat, retributive theory. Whatever you do for me, I will do back to you. Okay, like that. Retributive theory. This is called as tit for tat. And also we can say eye for an eye. Okay, you do something, I will do that back to you. Okay, so what is the aim of this theory? Offender must feel the same pain he inflicted to the victim. See, all humans are equal. So he has offended some human being. He must have suffered a lot. The victim must have suffered a lot. Okay, so you inflict the same pain on the offender who did the wrong. Then he'll be quiet. Right. So the offender must feel the same pain he inflicted to the victim. That is the aim of your retributive theory. So what is the core concept here? What is running behind this theory is that vengeance. You do something, I'll do back. That's what is vengeance. Okay. So it is also called as vengeance theory. Now, what is the benefit of this theory? By doing vengeance, what do you think is the benefit of this theory? You try to answer, then only you write the rationalize in your UPSC examination. You may feel that I am troubling you, but if you try to give answers, your answer writing will definitely improve. Your way of thinking will improve. Okay? Try to give something. Consider law experts as a family. That's why we have a very little closed group of batches for UPSC. Don't want to answer still. Only this batch is very quiet. Huh?
FIR.
Tell me, sir.
Increasing of FIRs, ma'am.
Increasing. Vengeance theory will increase the number of FIRs. Huh? Do you think so, sir? Okay.
Yes, ma'am.
Vengeance theory doesn't mean that he will automatically go and do it. That is, the victim will go automatically go and do the crime. It will be a crime again. That is, the state will ask the victim to do it. Say, for example, one person has cut the hand of Mr. A. Mr. A is the victim now. So what they will ask the person to do is, you have to go and cut the hand of the offender. Like that. It is permitted. Okay. So what he thought is good only. It will increase the FIR he is telling. But why? There are two benefits in this theory. First thing is that the victim will be pacified. See, I have suffered. Now he is also suffering. So there will be some pacification inside. See, I have got some justice, right? So that feel will be there. When victim is pacified, there will be no further crime. Just opposite to Karthik sir told. We do see gang wars, right? In villages and all, one particular family will come, it will hit the other family. One by one, they hit each other back, and it becomes the war of the entire village, and both the villages will be fighting. So like that, it will not go. Once the victim is able to punish the offender, they get pacified. So there is no multiple crimes, that is, no further crimes happening because a stability is reached. So this is called as natural justice principle. That was one benefit. See, I did not give all these benefits. These benefits were given by the thinkers. That's what we are going to write. But if you are differing, you can write your own rationally also. Okay. Now, then the offender will know. Only when we experience the pain, we will know the real problem of it. Okay. Whoever may be, who tell their story is different. We can listen to a lot of people's story and say that, don't worry, it will all go. But the person who's there in that situation only will know the veracity of the problem. Okay. Say, for example, when I was a kid, whenever my mother cooks good meal, what I'll say, Mommy, it's not nice. I won't eat. Why did you cook all this? I'll go outside and eat. I'll call father to bring something else. But today, as a mother, I'm taking all, see, I'll call my mother and ask, Mommy, can you send something in tiffin box? I'm craving for your food. So only when you come to the mother situation, you understand what it is. You will not be able to relate it, because I see all bachelors studying for UPSC. Once you get married, you will understand the importance of your father and mother. Okay, so that's it. Like that, the offender will learn how awful it will be to be victimized, to be punished. See, you have done something wrong to the other person. The same thing happens to you. They will say karma is a boomerang, right? Like that, if it is happening to him, he will know how much it is wrong. Okay, that is the second benefit. But you see, The most hated criticism is that it is an ancient theory. No matured society will use this. Okay, although we all say humans, we are at last animals, right? So we do like to take revenge. We do get jealous and we do all these things. But we have to be mature also. So revenge is not going to help you. Somebody suffering will not going to help you. But you should get justice at the same time. So what is the criticism here? A matured society will not practice vengeance. So that is the criticism. But can you say an example for this tit for tat vengeance theory? We have it in India itself. Somebody commits a murder. What punishment we can give? Retributive theory. For murder, what is the punishment? Nobody knows. Nobody knows what is the punishment for murder. So sad. All the non-law students.
Life imprisonment,
Life imprisonment and
death penalty.
death penalty, right? So you cause death, you will die. So that sounds like a retributive theory, right? So that you can quote as an example. So retributive theory, eye for an eye, tit for tat. The aim is like offender must feel the same pain. Whatever I suffered, he also must suffer. So what are the two benefits? One thing, natural justice, equilibrium is reached. You suffered, the other person also suffered. So the victim feels satisfied. Second, the offender gets the same pain. So he will know what wrong he has done. Okay, he will learn from his mistake. That is one thing. But what is the criticism? It is an ancient theory. A civilized society will not use it. Okay, so that is the thing. So hope you understand retributive theory. Can we go to the next one? Preventive theory? Can we? Will not go?
Yes, ma'am.
Okay, we'll
Ma'am,
go.
but I
Tell
have
me,
one
Nandita.
question. Ma'am, the deterrent theory and the 1 and 2, it seems similar. Like, what could be the difference between the two? The retributive and the deterrent.
Nothing much. I told you, right? The punishment, why do you give? It may be the same punishment. We can say murder for the deterrent theory, example, and example for retributive theory is also murder. But why murder is given? That question you ask, these two people will give different answer. You ask deterrent theory, why we are giving murder to that person, he will give an answer like saying that if I give a murder, I mean death punishment to this person, other people will watch this person and they will not do the same thing. It will deter others. So the explanation only differs. The reason only differs. Okay, that will be the answer from the deterrent theory. If I ask the retributive person, retributive theory, why did you give the punishment of murder? I mean, why did you give the punishment of death penalty? What he will answer? What this person will answer? He has caused the murder, death of some person, so he must suffer the same loss. That's why I am giving him the death penalty. So the reason differs. That reason difference only is called as theories. You understood, Nandita?
Yes, ma'am.
Okay, so we will have more reasons. See, if we will have a lot of latecomers in class. Okay, if ma'am asks why you are late, one will say, ma'am, breakfast got late. One will say, train got late. Ma'am, I fell down, one will say. Another will say, sorry, ma'am, mother did not pack the lunch. Okay, different reasons. All are late, but we get different reasons. These different reasons are theories. Okay, that's it. So coming to the preventive theory. This is like prevention means before something is committed, you stop it. That's what is prevention. But it is given two folds. One, we have preventive detention laws. We all know that only when an offense committed, a person can be jailed or given punishment. But these preventive detention laws are super hi-fi. You need not do any offense. They will see that whether you are going to do offense or not. If the police finds that you are going to do some offense, you look very fishy. You are a previous offender. There's going to be some offense you're going to commit. immediately on the apprehension of committing the offense, in future that you may commit the offense, they will catch you and put you in jail. That's what is called as preventive detention laws. Not only that, this will also prevent future crimes. Okay, preventive theory's idea is that. So the thinker of this theory is Patson. And what is the aim of this theory? Is to stop the offense. So offense shall not happen. Somehow we have to prevent the offense from happening. That is the aim. So what is the method they are using? They are disabling the offender from doing the offense. So how do you disable a person from doing the offense? First thing, see, in Indian marriages, we will enjoy a lot, we will eat a lot, but there'll be some auntie or uncle who will create a lot of trouble. Okay, although we do everything for them, they will not be satisfied. So what is the best way to avoid them, those uncles and aunties? No idea. These are just common questions, right? Hmm? What we can do? Best is
Stay away.
not to invite them. They're going to keep troubling us. Don't invite them. Like that. How to disable the offender? You isolate the offender from the society. How can you isolate the offender? You imprison the person. And there was an offense called as deportation, which means in Tamil they will say Naad Kadatal. From one place we will send the person to the another place. Okay, he will not be in that particular country or what. Okay, like that. So you isolate the person, keep him in jail, imprison him, or you deport him, send him somewhere. Okay, and next, eliminate them. See, we saw death penalty as an example in all the other theories as well. First theory we saw in retributive theory, deterrent theory. Here also in preventive theory, death penalty is supported. But what is the reason they are giving for death penalty? He has committed a heinous crime. If he is going to exist in the society again and again, he is going to commit the same crime. So what I will do? I will eliminate him from earth and I will send him to hell. Okay, that's what death penalty is also supported here. So in preventive theory, you are disabling the offender from doing the crime. Patson is the thinker. See how strongly he is sitting and thinking. Okay, so Patson is the thinker, and the aim of the theory is to stop the offense. How do you do that? You disable the offender. And what are the method you disable? One, I can imprison him. I can deport him to the other country, or eliminate him, finish him. Okay, death penalty can be given. So what is the criticism for this theory is that you cannot isolate everyone. See, there are people who commit the offense just because of the circumstances. They don't understand certain things. See, I don't advocate this. It is not my personal opinion, because nowadays crimes are very heinous. If we listen to those crimes, you will get a heart attack. Okay, but it is a theory. Yes, they're telling that. What about juvenile offenders? They do the offense only because they don't have maturity, it seems. Okay, they rape a 3-year-old girl, 6 months old baby, and they will say they are a juvenile. Even in Nirbhaya case, you remember who was the person who committed all the heinous act to that angel? It was the minor. Okay, so but that's my opinion. This is the criticism of the theory. They are telling that juvenile offenders must not be treated like that. They have a future. So you think about them. They cannot be eliminated. What about their future? So this theory cannot be applied to the juvenile offender. That's what is the criticism. So to support juvenile offender, what can be the measure? Think and let me know. What will be the next theory? He doesn't know anything. So we have to do something to help him. What will be the next theory? Every mother will come up with this idea. You see, if a son commits a wrong, see, sorry for being like this. I see in my personal life. That's why if a son commits a wrong, what they will say? He will get better. Okay. Right? Let's be practical. So only that his zodiac sign is not good. Okay. Once January goes and April comes, he'll be better. So he's not doing anything. Oh, the girl who is marrying the son, what she must do? She must take the responsibility and make good of her son. Okay, that was in my generation, but I think I'm a little bit of old generation. In your time, it will not be the scenario. I think you all will be equal and happy, leading a happy life. Okay, so now, so what must be done? We are all rehabilitation centers for the son. Okay, so it is like reformative theory. What's so hard? Change. Okay, next we are going to reformative theory. Reformative theory comes from this great person who is Mahatma Gandhi ji. Do you know one fun fact? We all will read like Mahatma Gandhi ji is the father of our nation. Is he really the father of our nation? See, I'm not creating any hate and all again. Legally speaking, whether he is legally father of our nation. What's your point on this? Do you think? Oh, it's so sad. I'm expecting answers from you people. I feel like I'm talking to myself. Why? Why so silent? Hmm? What happened, Bala sir? Yesterday you gave a lot of answers. Today you're very quiet.
I'm in the train and I can't able to answer.
You are outside.
No, I'm in the train. I can't able to answer.
You're not able to answer. Okay, sir. Done, done, done. Legally speaking, that title was not conferred to him, it seems, by Indian government. It was called. He was called by a nickname. That's it. Okay, and it was given in a speech by another famous person that you go and find out. So legally giving any title is abolished under Article 18 of our Constitution. So there is no father of a nation as such, but we will call him for his contribution for all the freedom fights. Okay, no derogatory marks, nothing like that. We do value him, but legally speaking, we cannot confer any title. Now, so what Gandhiji has told is that hate the sin and not the sinner. Okay, so someone commits murder, you hate the murder, the offense, and not what? Not the offender. So hate the sin and not the sinner. Based on this, we cannot say it's like something related to Gandhian principle. So someone does some wrong, we have to give a chance to change. To be frank, is there anyone in this world who have done no wrong? I myself have done a lot of things wrong, right? And we continue to do some wrongs. And we will ask for chances in life. Like that, he is telling there must be a chance to change must be given to the offender. So what is the principle? Nobody is born criminal. So when people are born, they are innocent. But the circumstance make them the criminal, it seems. Because of the circumstances, they do it. See, we cannot altogether ditch this principle. Say, for example, a person is starving, his entire family is starving. He has a very small kid who is 1 year old. If today he doesn't take the rice home, the baby will die out of hunger. So he goes and steals a bag of rice. Okay, whether you can altogether hate that person, you see the circumstance, right? He is innocent, but due to the circumstance, he has committed theft. So for these people, we can very well go for this theory. But I will say in these things and all, the person only is not the offender. The entire society, the government is the offender. So when one family is starving like that, it is the responsibility of the government as well, right? So all these people's life rest on you people like bureaucrats. You are going to be in straight touch with these people. See, a MLA, minister, CM, or prime minister, they're going to come for 5 years, go back for 5 years. When they will hold the post, we don't know. But bureaucrats, You're going to stay right there till your retirement. So how much change you can bring in? So we common people believe you all, be it a judiciary aspirant or a civil service aspirant, you are only responsible for us. Okay, so we will go ahead. So the principle, nobody is born a criminal. They are innocent. The circumstances makes them a criminal. Okay, so the circumstance overdo the character. They see that some people of weak character. So due to circumstances, they do commit problem. So it is like a disease. So what we have to do? We have to give them a chance to change their behavior. So how do you give them a chance? You do the reformation to them. You do in such a way that you make them understand you need not fall for these problems. You can do the alternative and live a good life. But in reality, whether this reformation works or not, I have no idea. The theory says you have to give a chance. Okay. And plays well with juvenile offenders. But in reality, we see once a juvenile goes to a juvenile home, or they'll not go to jail, right? Once they go there, when they enter, they will enter as a pickpocket, and when they come out, they will come as a big robbery gang, or in jail they will learn everything. That is practical. It's up to you people to change everything. Okay, so but in theory, it plays well with the juvenile offenders. That's what is given as the remedy and positive things. But the criticism is it is totally idealistic. Remember, a person is raping a 6 months baby. What reformation that you can give that person? He is raping a baby in diaper. They will ask like what dress the baby wore. Will they ask? Okay. So what reformation that you can do to that person? What you will do? Whether this theory will work for him? It will not work, right? So it is totally idealistic. That is a basic criticism. You got the idea of reformative theory? Can we go to the next theory? No? We will stay in this theory? Okay, at least Karthik sir is giving a thumbs up. So I'm getting motivated to go to the next theory. Okay. So next theory is a very, very funny. Yes, if you're not able to answer, you can give at least a thumbs up. Okay. So now we will go to expiatory theory. This is the funniest theory of all. Okay. So it says that it's reliving yourself. Okay. Reliving yourself, which means self-realization. So you commit a crime and you say that, Chocho, I have committed this crime. Yo, I should not have done this. Once you do this, you got the self-realization. It means you have to be forgiven for this crime. This will not happen even at our home. We do something wrong, at least they won't talk to us for a month if it is very serious. Okay. If we are very small, nobody has got beatings, right? Now people are not, father and mother, parents are not hitting you, right? I just want a clarification. Huh? When you were small, I and all got nice kickings. That's why I'm asking. No? Nandita, what about at your home? Only
Ma'am,
advice?
even now I get.
Appa, I feel happy and satisfied now. So what about Karthik, sir? He won't get anything?
Ma'am, in childhood I get, ma'am.
In childhood. Okay, fine. If I touch my baby now, I'm getting a lot of scoldings from my parents. So I'm not allowed to hit her. Okay. So today things are changing. Now, coming to expiatory theory means self-realization. You realize that what you have done is wrong. That is totally enough, it seems. That is totally enough. You must not be punished. Once you realize, it is enough. Okay. So what is the aim of the theory? Help relieve oneself from the crime committed. It is like Jesus, right? If somebody hits you in one chin, you have to show the next side, it seems. Okay. To slap. I don't know how it works and all. Even I don't believe in Gandhiji's Satyagraha. Okay. Like you keep quiet when people are hitting you again. I don't know personally. Okay. So the method. What is the process they are telling? Process of self-realization. It is linked with religion. Actually, I told, right? Jesus says, if someone slaps in one side, you show the other side. Like that, it is related with the religion. So what is the result? Once the offender self-realizes his fault, he repents. Then what he must do? He must forgive this person. See, if there is a husband and wife, and if the husband cheats, and he comes back to the wife and says, "Oh, you, I'm very sorry, ma." They will say, right? "I'm very sorry, baby, ma. You just forget me. I mean, no, forgive me. Not forget, forgive me. I'll take care of everything else." Then immediately the wife must say, "Oh, don't worry. I will forgive you. I will live with you happily," like that. Okay, I don't know whether it will happen. I think the curry and cyanide case will happen. Okay, that is different. So this is what the theory is expecting. What you must do, once the offender asks sorry, you must accept it. So you all are going to follow this in your life. Okay, that is the thing. What is the criticism here? It is too idealistic. Who can follow this? I cannot follow this. Okay, I'm just a human. You do something wrong, I'll be upset. I cannot just leave you off hook. Certain things we can do it. Certain small wrongs we can do it. Moral wrongs to certain extent we can do it. But what about the offense? It is very serious, right? So it is too idealistic. But this theory will allow compensation. So you have created some loss to the other person. Once he feels sorry, leave that person. But you have created any monetary loss. You have done something very bad. You can give compensation. Okay. So we call it also as compensatory theory. Okay. What is the criticism again of this theory? How much compensation you can give for murder and rape? For human life, whether we have amount or rate fixed, you commit a murder or you do a rape and give money, will that be fine? Not fine. So this theory will not apply in many areas. Okay, so this expiatory theory is very idealistic. So you understood all these theories? Expiatory theory understood? Okay, you can give me a thumbs up so I understand. Okay, now. So the question is, in India, what theory we practice in India? No other go, you have to answer me.
Ma'am, mostly deterrent theory.
Mostly deterrent theory, Karthik sir says that. What about Nandita and Bala sir?
Deterrent and reformative both.
Yes, deterrent and reformative. So the thing is, in India, we follow multiple approach. Okay, so like making sambar in South India, what we will mix all we want, right? Like that, we follow a multiple approach upon the situation. So not specific theory is chosen. Actually, for juveniles, we see the reformative theory. If it is very serious, we go for deterrent theory, like that. And we have community service also, which is somewhat like an expiatory theory. You do something good to the society, very small wrongs. You do something good to the society. You realize what you have done is wrong. You are out. Community service. Okay. Like that, we follow a multiple approach. Okay. Now we are going to the 1 second. Yes, now we are going to the actual punishments. So we have completed the major area. Now we are going to the punishment. Punishment is listed under section 53 of IPC and section 4 of the BNS. If you see, the first punishment clause A talks about death penalty. Secondly, you have imprisonment for life. That is not a simple imprisonment. It is imprisonment for the remainder of your life. Imprisonment for life. Okay. And the third one is transportation, which is abolished now. No worries about that. And fourthly, you have normal imprisonment, which is of two types. One is called as rigorous imprisonment. Rigorous means you have to do hard labor. They will say like you're going to prison and you're going to break bricks. Okay, break stones, do hard labor. Yes, rigorous imprisonment means with hard labor. It is a compulsory labor. You have to do it. But simple imprisonment means no labor. It's optional. If you want, you can do it. Okay, that's what is simple labor. And finally, forfeiture of property. So forfeiture of property is the court will attack the property, take the property away. That's what is called as forfeiture of property. And these are all the things given in IPC. But in BNS, we have a bonus. That bonus is the fine we have left, So fine is the last one. Fine is like an amount that whether that fine amount will be paid to the victim, amount collected will be paid to the victim. Certain cases it will be paid, but mostly it should be given to the state treasury. Okay. So fine. And finally, the bonus that was given is community service. This is the new one. So now coming to the question. Community service was introduced by BNS. Okay. So whether early BNS came in 2023. So before 2023, there was whether there was anywhere the punishment of community service was given, whether it is totally new, it was only introduced in the BNS. No, nothing like that. BNS came in 2023, and even before 2023, we have courts giving community service punishments. So they have added in IPC, that is in BNS, only in 2023. Already it was existed. Okay. So we have a 2012 case as an example. In this case, they would have given community service as a punishment. You can note down the case. The later point of time, I will send you through. We have a lot of cases. So this is one such case. So the thing is very simple. It is not, community service is not newly introduced in the BNS. It is an addition, yes. But earlier to the BNS also, we had this community service. Courts were giving that. Okay, so it was a usual practice. So nothing new. Okay, now what is the definition of community service? What are the other areas? We will see at the later point of time. We have separate slide. Just have an idea. We are listing the punishment. We have death, imprisonment for life. Then you have two types of imprisonment, rigorous and simple. Then you have forfeiture of property and finally fine. And you have the bonus, which is the community service. We are just listing the punishment. Okay. So this listing of the punishment is very important because if you see in the earlier time, like in Rajaraja Cholan time and in Islamic time, in Mohammedan time and all, Ashoka and all, if someone commits an offense, they will give weird punishment. Go cut this off from him. Go do whatever the king feels he will do. If the wife does not treat the king properly, he will come to the court and chop everyone off. Whatever he thinks, that is a punishment. But today, even if the judge's wife is not treating the judge properly, he does not have a liberty to punish anyone as he like. He can choose only the punishment given by law. Okay, it is a curtailment here. Okay, hope you understand. Now, coming to death penalty. Death penalty is given in a lot of offenses. Say, for example, for murder, for waging war against the government, for abetment of mutiny, for dacoity with murder and all, death penalty is given. Even for rape, death penalty is given. But this death penalty, whether this is constitutional, that will be asked again and again in UPSC. Okay, now when we talk about death penalty, in USA, death penalty was prevalent earlier, and in 1967 to 1977, it was suspended. In this period of time, they told that death penalty shall not be given. Okay, but now in the present scenario, US have death penalty. See, suddenly they are bringing the guns and they are going to the kindergarten and shooting everyone. Whether this person must be kept or he must be given death penalty. He must be given death penalty, right? So US has death penalty. They have suspended it only for these years. Okay. But you go to UK, United Kingdom, whether they have death penalty. European laws. Europe is known for their human rights. So think and say, you can Google also and say something. What happened? Very quiet. Future civil servants. No idea. You people must know more general knowledge than me. I'm not going to write prelims. I'm not going to write GS, right? Must give a lot of answers, right? Okay. Do you know UK has a death penalty or not? Any answer. Yes or no is enough. I'll tell you the right answer.
I'm just Googled, ma'am.
No.
I'm just Googled. Most of the cases there is no penalty.
Yes, in European countries, they have altogether abolished death penalty. Okay, they are very pro for human rights. So in UK, there is no death penalty. It is abolished now. Okay, but in India, we have death penalty. I will advocate for death penalty, but we will see what is the legal points. Okay, so if you're talking about legality of death penalty, you have to touch Article 21. It gives you right to life and personal liberty, but it is not an absolute right. You cannot do anything in the name of freedom of life. Okay, so with the procedure of law, if the life can be taken, then it is allowed. So no person shall be deprived of his life or personal liberty except according to the procedure established by law. So if there is a procedure to take away your life, and that procedure is fair and just, then your life can be taken away. That's what Article 21 says. So where do we have this procedure? We have it in Criminal Procedure Code and BNS now. Okay, then not only in IPC, in army laws, in navy acts and terrorism control laws also, we have death penalty. We will think that only in IPC and BNS we have death penalty. No, not like that. Even in POCSO Act, there is one place where they have given death penalty. Okay, so what are the ways of fulfilling this death penalty? In America, I think I have seen only in films, what they will do, they will put this injection, right? What injection they will put? I think it is something like a poisonous injection they will put, right? So I have seen in films only. But in India, what they will do? How they will fulfill this death penalty? What is the method?
Hanging,
By hanging, yes. So hanging is done one way for the civil laws. But if you're doing any offense in Army or Navy Act, okay, then you will be shot dead in under the martial laws. So 2 ways death penalty will be completed. Now, what is the legality of the death penalty? We have 2 important cases. First important case is Bachchan Singh versus State of UP. This Bachchan Singh story I will tell you. You would have heard about this case law, but what are the facts I'll tell you. Okay, he has killed 3 persons. Okay, and he was awarded death penalty. He will go to special leave in the form of special leave petition to Supreme Court, and Supreme Court will confirm this death penalty. Now he will say that, see, Bachchan Singh's advocate is very intelligent. If he goes and argues in the court that you are violating my Article 21, death penalty shall not given, the court will not hear him. So what he is telling, there is a golden triangle principle which was pronounced in Menaka Gandhi was Union of India. So now you understand, Bachchan Singh is the case we are talking about. But the advocate of Bachchan Singh is quoting another case. That other case is Menaka Gandhi case. So why he is quoting is that in Menaka Gandhi case, they have come up with this golden triangle principle. What is this golden triangle principle? See, if a woman marries into, see, always I go with the home example because that hits hard. So say if a man marries a girl, okay, who all he must satisfy? If he wants to marry a girl, who all he must satisfy? He must impress the girl first and then impress the girl's mother, saying that, see, I will take care of your little princess well, okay. And then he have to satisfy the girl's father. So 3 persons must say okay in order to get married. Like that. For a law to be perfect, what it must do? It must satisfy Article 19, it must satisfy Article 21, it must satisfy Article 14, it seems. So these three are related together, golden triangle. If any one of here, any one of the article here is violated, it means the law violates all the three articles. Okay. Here also, like, if the daughter gets offended, immediately the mother will cry, the father will take the rifle and go to the son-in-laws. Like that. Okay. So, if one is offended, the other two will be shaken. So, he is coming to the point. He is not arguing Article 21 is offended. Bachan Singh's lawyer is telling Article 19 is offended. So, how Article 19 is offended, you think? 19 gives all the freedoms here. So he's telling, you take away my life, you will kill me. How I am going to express my freedom of speech? How I am going to form association? How I am going to travel? How I am going to reside in India? How I am going to do the profession? So all my freedom you are taking out without any reasonable restriction. That is his argument. I find it to be little lame. Okay, so that's what his argument. Anyway, he must get his fees, right? He has worked up so much and he's arguing. And we got a golden case law. That is different. So that thing he told. So then he told that there is no ample procedure. See, death penalty is there. On what basis you will give the death penalty? What is wrong to me 50% will be wrong to someone else for 30%. See, there are certain people who will not accept gay marriage, same-sex marriage and all, right? But there are people with open mind who will say, see, if you are happy, it's fine. Okay, it differs from face to face. One judge may feel that for this particular offense, we must give death penalty. Another judge must feel that, no, it is okay. We need not give death penalty. So there is difference in opinion, right? So it is violating Article 14. There is no proper yardstick. There is no proper procedure. That was his second contention. I like the second contention. See how intelligently he puts in. Opinion differs from face to face. Each one will say something. So how do you make a proper scale that everyone gives a death penalty? That was the question. For that, our Supreme Court gave two good answers. First one, they told, see, come here. If Article 19 is violating, Article 19 is not absolute. We have reasonable restrictions. For public order and peace, we can restrict Article 19. You can talk nicely, walk nicely, sleep nicely, but don't murder 3 people and try to do all these nicely. That's what the court told. Okay. Next point is, you want some rules, right, to be laid down, but everyone follows the same yardstick to give death penalty. Don't worry, if there is no guidance, we will lay down the rules. We will give you the guidance. And they formed this rarest of rare case doctrine. So if it is a very rare case, if it is something out of blue that is happening, then you give the death penalty. So Bachan Singh is known for rarest of rare case doctrine. Wait 1 minute, let me switch on the lights. Yeah. So the Bachan Singh case law gave this rarest of rare case doctrine. So what this doctrine says is that crime is so heinous. It is a very, very serious crime that it shocks the entire society. Can you give an example of such crime which is happening in our society? Anything which you came across? Very bad thing happened. Like that.
Honor killing.
Honor killing.
Honor.
Okay. Honor killing. Anything else?
Nirbhaya rape case.
Nirbhaya case. RG Kar case. It is rarest of rare case, but the judge ruled that it is not rarest of rare case. I would like you all, if you are a judicial service aspirant, don't waste time if you are in UPSC. Go and read the district court judgment. But the judgment is because there is no direct evidence. If he gives a death penalty, it will go higher and it may get reversed and he may be let out. Okay, so we have to see the other side also. That is totally different. But I'll say that it is a very heinous crime. If you go to work, you expect a little bit of safety. Okay, so that's one thing. Uh, Honor killing is also very, very hideous. Okay, you take care of the kid so much. Yeah, some other person, you kill the other person just because they marry the person who they love. Okay, that's very sad. So crime is very heinous. It shocks the entire society. You have to see. Okay, if it is yes, give death penalty. Next, life imprisonment is a rule, but death penalty is an exception, which means whatever offense for which they will not give only one option. They will give you two options: either imprisonment for so much or death penalty. So maximum the judge must try to give what? Life imprisonment. But if there is any special reason, only what he will do? He will give death penalty. That's why we will say life imprisonment is a rule and death penalty is an exception. And we have section 354 clause 3 of CRPC and 393 of BNSS, which supports this. In this, they will say if a judge wants to give a death penalty, he must mention the special reason in the judgment itself. So what is the final outcome? Life imprisonment is a rule and death penalty is an exception. Okay, so that you must know. Next, because of this statement, they must give the special reason. That's why I have told you. So you see the dimension of the crime, how serious it is. It is so heinous that it shocks the society. Totally enough, it is a rarest case and you're going to give death penalty by giving the reason. So in the answer, you have to write all these 3 lines. Please take these lines after the class because without these lines, the doctrine of rarest case will not be fulfilled. Okay. Now, going to the Machi Singh versus state of Punjab. Here, tell me,
Can you explain
Karthik.
last point once again?
Last one, special reason.
Yes, right.
Yeah, see, if Karthik is a judge and he wants to give punishment to someone, okay, and he wants to give death penalty, he cannot write like death penalty is awarded to him, hang him till death. Only that is not enough. He have to mention the special reason why he is giving death penalty. Okay, he has committed such a huge crime. Entire society is shocked because of his crime. So I am giving death penalty. That special reason they have to mention. Okay, that's what is the last line.
Okay,
Okay,
ma'am. Thank you.
done. So coming to Machi Singh case, you see, regarding rarest of rare case, they have given only one line. It is so heinous, that is enough. So the question comes in Machi Singh versus state of Punjab. What is heinous? See, you have stated only one line. It should be heinous. How do you measure the heinous? You have to give some criteria, right? That was the question. What happened in Machi Singh is very, very sad. Actually, it is a family fight, okay? More than 17 people would have been killed. So the other party, to seek vengeance, they will go into the house of the victim's place and they will kill all the sleeping persons. The mother, father, even small children and ladies, even an 80-year-old, I think, a person will be killed. How can a person kill a sleeping baby? Okay, so he would have killed all these entire family member. Okay, so the court will say, we will lay down the criteria, which is heinous. So first they will say, consider the manner of commission of the crime. See, suddenly one person comes, cut one person or something. Okay, I don't say it is okay, but comparing to a person comes and cut the person into pieces, and then you put the person in the acid, in all those things. How heinous is that? How serious is that? So manner of commission of the crime is important. So he has killed the sleeping babies. How sad is that? Okay. So what is the motive? They will do murder just for property. They will kill their own brother's family just for property. It happened near my home. Actually, we all thought it was the problem of the AC, and the AC burst, and the entire family died. But the brother itself has killed all three children, and his brother and his sister-in-law poured kerosene all over, lighted them. Okay, so for what he's doing, what is the motive? Okay, that you have to see. Just for money you do, that's very serious. Okay, next, the magnitude of the crime. How many people you kill? What you do? See, 3 children is killed, 17 people killed. It's all serious. Next, anti-social aberrant nature of the crime. How it is creating unrest in the society. That is very, very important. If you know that, if I hear that some women who is going by and she has been molested, I feel very, very difficult to walk in the same street. And I feel that a murder, or see, imagine your next house is robbed and today you're sleeping in your house. How you will feel, right? It will have an impact. Like that, the anti-social aberrant, what impact it has on the society, that you must see. Then, the personality of the victim of the murderer. The victim is very helpless. They are killing the children, aged people. You see the mentality of the person. There is a category called rowdies or guttas. They are going to fight another rowdy, another gang leader. Fine, okay. But they are going to kill the innocent people. That is different. Right? So all these things you take into category and then decide whether they are rarest of rare cases. So they gave the yardsticks. Okay. So first, in Bachan Singh, we got the doctrine, rarest of rare case. But to apply the doctrine, we got the yardstick, the criteria only in Machi Singh. You got the idea? Any doubts here? We'll go to the next. Okay. So now, how do you decide? I told, right? We have an option whether we can give a life imprisonment or we can give a death penalty. How the judge select this option is that they will have a sentence hearing. If I have called out one section for you, need not write this section, just understand that's totally enough. In sessions trial, because there are only 2 courts which can give death penalty. Oh yeah, of course, Supreme Court can give. When we are talking about a state, we have the sessions court that can give death penalty on confirmation by the High Court, and High Court can give death penalty. So sessions court trial, in section 258, they will say that if you are passing death penalty, you have to give not only death penalty, any punishment. You have to do a question on sentencing. Before passing a sentence, you must give an opportunity to the accused side to explain all the mitigating factors. Sir, and that time I was in a sudden rage. Sir, I am just 21 years. I am the sole breadwinner of my house. Then you should have been quiet and not do this offense. That is different. But he will give all the mitigating factors. Okay, that you have to take into consideration. Now, why death penalty must be given? That you have to ask. So you give an opportunity to the person who is going to you are going to award death penalty. He will give all the reasons. See, these are the reasons I have committed this heinous crime. Although it is heinous crime, I am very sorry. He will literally say all these things. Once you go visit the sessions court, you will get all these weird answers. Latest in Kanchipuram, they have given a death sentence which is very famous. A mother has killed her own 2 children just for the extramarital affairs. When the sentence was read over to her and told that, see, you get an opportunity to give all the mitigating factors, you know what she told? She told that I have 2 old parents, aged parents. So if you give me death penalty or if you give me life imprisonment, then how I will take care of them? The judge asked the right question. You cannot take care of your 2 children, not even take care. You can left out them in some orphanage, but you killed them. And now you want to take care of the parents, which means she is going to give another, killed another 2 souls. Okay, so like that they will give all the rubbish answers. Really, they will give. Okay, so in sentence, but legality, we must give them sentence hearing. So why death penalty need not be given? A chance must be given to the accused, and the judge will listen it. That's called as sentence hearing. Okay, and now there is a section 303 of IPC which says that death penalty awarding punishment to life convicts who committed murder. See, already the person committed murder and he is in prison. life convict, and that life convict again commits murder. See the thing, he may committed that inside the prison, or he must have escaped or went for a parole somewhere outside also, he committed the murder. Okay, for those persons, what can be the punishment? What can be the punishment? Already life imprisonment. So what is the next punishment that we can give them? Think and tell me. Simple. Another death penalty only can be given, right? More than that. So that was the only option given in 303 under IPC. It was struck down in Mithu Singh case, telling that judge must be given option of 2 to 3 punishments. Then only it is just. So in BNS, if you see same section is referred in 104, they will give an alternative punishment. Life convict, not only death penalty, he can be awarded another life imprisonment, double life imprisonment, something like that. So simply option is given. Okay. So this is not important. Just you understand. That's all. Not important. So sentence hearing must be given. Same day sentence hearing is good. So today you declare someone to be an offender. Same day you hear all the things that he is trying to say, like I have done this, all these things because of these reasons, hear all the mitigating factors and pass the sentence. That's what they are telling. But giving same day is really hard sometimes. It needs a lot of preparations for the other side. See, accused side advocate must prepare, right? Whether he will know that today he's getting the punishment. Suddenly he knows that, yes, whatever he argued, the judge did not hear that, and he is giving the punishment. Okay, he was going to prepare all the mitigating factors and come back. So, for full and effective representation, time can be given for sentence hearing. That is also given. They are not going to concentrate on sentence hearing, but it is good if you mention 1 to 2 lines about sentence hearing and death penalty. Okay. Now, this is not important, so we are skipping that. So, for capital punishment, we have both sides. Now, there is an issue, right, regarding street dogs. Few say, we don't need street dogs, kill them all, or do something, separate them from the society. Few say, no, you have to show leniency to the street dogs. We always have two sides. There was one news where a baby who was sleeping in a small cradle outside. See, many don't have the luxury to have a very good cradle at home inside. I myself have slept outside in cradles. They will use the sari cloth to do it. In near trees and all, they will do it. So like that, a baby was sleeping, and 2 to 3 street dogs came there, took the baby, and they almost ate the baby, and the baby is dead now. Who's going to bring back that life? I don't say for this we have to kill the dogs, but do something that innocent life is not dead. Okay, so that's one thing. Like that, for capital punishment, there is always for and against arguments. As a upcoming civil servant, you have to write that in your answer. Okay, so what can be the for arguments? It is a retribution. See, one murderer is there. He has killed a lot of babies or something like that. He's a chain murderer, serial killer, and you take him to the jail, give him a lot of food, and take care of him. It is draining public finance. With that, you can feed others, right? Who doesn't have money. You can give midday meals. Already they're giving midday meals. They can give the night meals also for the kids, right? So, draining public finances. Unwanted people, kill them. Get away with them. They are telling. Next, deterrent effect. You kill 2 people who's committing heinous crimes. Honor killing. Whoever do honor killing, we will kill that person. Or whoever doing rape, immediately kill them before everyone. Then what they will do? They will think to do offense again. Okay, so deterrence effect will be created, and will of the citizens. Most of the citizens feel that death penalty is good. So these are the arguments. And what will be the against arguments for the capital punishment? They will come like this. See, there is human life value. There is right to life. I ask one question. I always have this doubt. Only the offender is a human being and he has human rights. What about the victim who dies? She is also or he is also a human, right? She does not or he does not. The victim does not have human rights. What is this? So that's what they say. First of all, they will say it's a human life. How much ever money you give, you cannot bring it back. And the human rights are available only to these offenders. Okay. Next, execution of innocent. This is a point to think. In India, can we say that only the right person is convicted? No, the process is flawed sometimes. That's why half of the cases of Sessions Court is reversed in High Court. From High Court, it go to Supreme Court, it is reversed. And if we have a higher court than Supreme Court, what happens? Again, it will get reversed. Okay, so sometimes judiciary becomes a joke. I'll accept that. That's what is reality. So execution of innocent person, if you kill the innocent person, what will happen? So that was the thing. Then retribution is wrong. You be like a sadhu. Don't kill anyone. They are telling. Next, failure to deter. Sometimes, even though you kill, especially in honor killing, even though they know that they are going to be hanged, they will say that I'm doing this for my community. You had my photo there. You create a statue for me. You worship me. I'm going to sacrifice my life and kill these people. See, what nonsense is this? I have seen one talk show. We do have Mia Nana, right? Most of them are South Indians, I would say. Most of the people are talking like that. I'm shocked to the core. I don't know how publicly they're talking. Okay, so there is failure to deter. We have to do something else for them. Okay, applied unfairly sometimes. It is true. Sometimes it is unfairly applied. And racial, ethnic, social classes bias. There are bias. We are humans. There are bias. So because of bias, death penalty will be given to the wrong person. So all these things are against capital punishment. So you do quote all these things and give your answer, which is very, very, very important. Now, coming to life imprisonment. Life imprisonment means it is not 20 years. It is not 14 years. Life imprisonment means till the remainder of your life. Okay, that is life imprisonment. Real meaning of life imprisonment, till you die, you stay in jail. That's what is life imprisonment. That is given in Vinayak Godse versus state, which is very important. But before that, we have reached our time limit. So it is you have to tell me whether we will have a small break and continue or we will continue tomorrow. It is up to you. Because it is you people who is listening.
Continue.
We can continue? Okay. We'll take a small break and continue. I'll also go drink some water and come back. Okay.
Yes,
We'll
ma'am.
take a 10 minutes break. Okay. We'll finish off soon. 10 minutes and I'll come by 6:30 it is now. So we will come back by 6:40 and finish off as soon as possible. Okay. Thank you. Okay, we will restart now. Hope you all right there. Now we were talking about life imprisonment. Okay, life imprisonment means till the remainder of their life. It is not like for 14 years or 20 years. Okay, but you have to know why do we confuse with this 14 years? Life imprisonment means 14 years. Why do we come to that point? Conclusion is because in prison rules and all, we will have this provision. If a life convict is showing good behavior for 14 years, if he is very good, then the prison officials can consider him for commuting the sentence, for making less the sentence, for remission of the sentence. Who will do this remission and committing is it is the president will do or the governor will do. They will say according to section 433 and 433 capital A, they will say that we have BNS sections quoted here. Both are here. So you can learn both. They say appropriate government can commute. Okay. So just because we can commute not more than 14 years. See, if at all a person is given a life imprisonment, he must be in jail for the remainder of the life. But he's showing good behavior. Okay, then the jail authorities will refer him for commutation. Then the appropriate government, what it will do, it will either commute the life imprisonment, that they can commute, maximum they can make it less for 14 years, not more than that. See, already life imprisonment, his age must be something 30 or 40. He has spent some 14 years and I commute it for 20 years. Will that work? Within 20 years, he is going to die. So making less also, you make within proper thing, right? See, you're making less a life imprisonment. You make it 20 or 30, 40 or 50. It is not useful. He's going to die anyway. You need not lessen it at all. That's why we have a limit in CRPC and BNSS telling that you are trying to lessen the sentence, right? So lessen within 14 years. Give 10 years, 5 years or something like that. Not more than 14 years. So that's why we confuse life imprisonment with 14 years. See, all these concepts are not important. That I want to establish the fact that life imprisonment means till the remainder of life. That's all. Okay. That was given in this Vinayak Godse case law. That is very, very important. Now, coming to this case law, Mohammed Munna case law, it was given in 2005. They have specifically mentioned life imprisonment is not 14 years or 20 years. It is still remainder of life. They would have specifically mentioned. So you can quote these two case laws. And now we have a judicial innovation. Our judiciary. See, even if our ISRO scientists will invent lesser than our judiciary. Our judicial innovations are very high in number than the ISRO scientist. Okay. So what happens? I have told you, in India, there was a debate that we have to abolish death penalty. We have to abolish capital punishment. So what is the alternative? So the judiciary came up with a good idea in Swami Saradananda versus State of Karnataka. They told that, see, we cannot abolish death penalty, but we will try to avoid it. How we will avoid it? We will give a life imprisonment with no commutation. So a rigorous life imprisonment where even if you show good behavior, even if you are a very good person, we are not going to leave you out. Okay, no commutation. Now the next question comes in. The commutation power, where it is given? To the governor and the president. In which law it is given? Remission, commutation powers and all?
Constitution.
Constitution, right? Whether this case law is against constitution, we can say, right? It is curbing the constitutional power. That point was brought out. See, you say no remission, then you are curbing the constitutional power given to president and to the governor. That was a point raised. In the same case law, they told, no, it is completely constitutional. Because the main work of the executive is not judicial work. So we decide the punishment and it is constitutional. So that was the new invention. And see, it is not new now. It is something new that is brought out. It is a old case law actually. So based on this, we have got a previous year question as well in UPSC. I'll give the contents of the question also to you. Okay. Now going ahead. When we talk about imprisonment, we have two types. One is simple imprisonment where the work is optional. But rigorous imprisonment, no choice at all. You have to do hard work. Again, I remember the home. When there is a couple, the husband is there, he has choice. Either he can do all the works at home, help the wife, or he can go only for work, come back and ask for tea, coffee and enjoy his married life. Okay, so it is, marriage is imprisonment for sure. So husband is enjoying simple imprisonment. But you know about wife, we are enjoying rigorous imprisonment. No choice. We have to do the hard work. Either we do the office work at office. We come back, we do all the work at home. So no option. We do only work. Okay. That is our choice. We have chosen it. But I'm saying, so simple imprisonment, rigorous imprisonment. And then we are talking about certain imprisonment which can be partly simple and partly rigorous. So 2 years of imprisonment, 6 months simple, 1.5 year rigorous. Like that also it can be awarded. This was stated in section 60 of IPC and 7 of BNS. Okay. Next, it is stated that no person can be compelled to work. Okay. See, compelling a person to work is called as what labor? We will see in constitution, right? What labor we will say?
Bonded labor.
Bonded labor, right? That is abolished in constitution. But in rigorous imprisonment, they ask for compulsory labor. One bright mind went to court telling that it is violating constitution. But they told, no, it is an exception because of their behavior. It is a punishment. So it is an exception. Rigorous imprisonment, yes, we can compel the person to work. That was also given. Okay. Now, I have to inform these things. What we saw in life imprisonment, Vinayak Godse case, this case law, and new innovation in Swami Sharadananda case law is all very, very important. Repeatedly asked. But what we are going to see in upcoming slides have never been asked at all. But for the sake of the examination, we are going to just know about them. Okay. Let me be frank. So what you have to read, what you have to revise, be clear on that. Now, in this case law, what happened? They would have given a simple imprisonment. So they told there is no compulsion to work. But if you work, remuneration must be given. Even near my home, actually, I'm staying near Pulal. Okay. We have Pulal prison. So near the prison, we will see this bakeries and also we will see this petrol bunk. Okay. They will call the petrol bunk Freedom Petrol Bunk. They don't have freedom, but the bakery's name is Freedom Bakery and Freedom Petrol Bunk. I should say this. They will give a good quality petrol. When I go there, I'll say like, Anna, 2,000 rupees. All see, I'll give good respect. You put the proper thing, I'll give the money, I'll run away. That's it. Why I go there is that we will get a quality product, so that I will go there. Okay. So the thing is, they are working, right? For that work, they must be paid remuneration. That you remember. Next, coming to solitary confinement. Solitary confinement is a thing like happiness. Now we crave this. After getting into family, children and all, I feel like one day you leave me alone. I'll pray to God. Okay. But this solitary confinement, they say it is a punishment now. Okay. Under section 73 of IPC and 11 of BNS, we see solitary confinement. This solitary confinement has a lot of criteria. We can stay alone. How long can we stay alone? We are animals and Homo sapiens. Man is a social animal. We need to talk to someone. Okay. You think that we can stay alone, but if a phone is given to us, we will stay alone even for 2 years, even for 10 years. But if we take away the phone and put you in a proper room, and if you are all alone, then it will be a solitary confinement like that. Okay. So we can give maximum only 3 months as a solitary confinement. This is not important. Just we are understanding. Okay. And for 3 months of imprisonment, you cannot give all 3 months as solitary confinement. Only 1 month you can give as solitary confinement. And if it is imprisonment is from 6 months to 1 year, in that 2 months can be given as solitary confinement. If the imprisonment is more than 1 year, for anything, 10 years till 10 years or life imprisonment, maximum you can give only 3 months of solitary confinement. And they cannot be continuous as well. You have to break it into 14 days, but that is only important for judicial service. So we are skipping that. I told you, right? This is not important. Just discussing with you. That's all. So cannot be awarded when imprisonment is not a major part. See, there are offenses where only fine is awarded. Okay, for that, whether you can give solitary confinement, you cannot give. So major part of the punishment must be imprisonment. Only when you have imprisonment, You can give what? Solitary confinement, solitary imprisonment. Okay, that was the thing. Next, solitary imprisonment cannot be awarded in lieu of fine. You have to understand there will be an option like you are sentenced for 5 years of jail and pay 20,000 rupees as fine. Okay. And if this person doesn't pay the fine, what we can do? That is called as default of fine. So if the person is not paying the fine, it is called default of fine. For this default, we can give extra imprisonment, bonus. Okay. This is called as imprisonment in lieu of default of fine. For default of fine, can we give solitary imprisonment? We cannot give. Okay, that is the thing. Because solitary imprisonment is very high, considered to be very, very serious. Tell me, Bala. Hello? Any doubts?
Sorry, ma'am. I'm in travel.
Okay, done. So, for default of fine, you give one imprisonment. That cannot be a solitary confinement. That was one thing. Okay. And the whole term cannot be a solitary imprisonment. You imprison a person for only 1 month. Okay. And the whole 1 month is solitary confinement. Go die in silence. That you cannot give. Okay. The whole of imprisonment cannot be solitary confinement. Just read all these. That's totally enough. And then you have forfeiture of property, which is the next type. Forfeiture of property, we have that is given as a punishment in all these areas. Just read at home. But there is one case law, Birjilal versus State. What happens? He would have committed offense with a rifle. Okay. The police would have come and confiscated the rifle. And immediately in the court, he will say, see, they have forfeited my property, which is a punishment for me. So why are you giving me another punishment? Double jeopardy, he will claim. So is it right? Someone kills another person with a knife. You take the knife. Whether that can be regarded as a punishment? No, right? That's what given in this case law also. Confiscation of weapon is not a punishment. So forfeiture of property must be given at the end of the judgment. We are attaching all these property because you have committed all the offense, something like that. It happens in cheating and all sometimes, okay? And even any proceeds of crime that can be attached now under BNSS. Very powerful section, okay? That is important for judiciary again. So we will skip all these. UPSC law optional is easy as that. Only certain things you read, you get the mark, go sit happily. That's all. Because you have bigger problems for you. Dinosaur, Godzilla, Gorilla and all is coming for you, which is prelims and GS. Now, coming to community service. Do you know where is community service defined? You can see the screen and answer as well. Where it is defined? Under BNS IPC. Community service. BNS IPC. Defined there?
BNSS.
Yes, BNSS. Under section 23, explanation of BNSS, they have told that work which a court may order to do for what? For the benefit of the community. Okay, anything that benefits the community, some work is given to you as a punishment. That's what is community service. For taking away all the unwanted trees, you can even take an order to clean bathrooms or to take classes somewhere or something like that. Okay, but whatever work you do, there shall not be remuneration. You go to jail and you break stones. For that also they will give remuneration. But for community service, they will not give remuneration. That's very, very important. Remember the definition. For what and all community service is given? If a public servant engages in trade, public servant must not do any other business, right? So if he engages in trade, he will be given community service as punishment. And there is a special type of offenders called as proclaimed offenders. Even when they are called by court, they will not come. Proclaimed offenders. For them, punishment is community service. An attempt to commit suicide to compel or restrain the public servant. See, the wife may love the husband so much. If the police is coming and arresting the husband, she may say that if you arrest my husband, then I will commit suicide here. If she says like that, for her, we can give community service. Okay, that's what is like this. Then for theft, also community service is given, but he must be a first time offender. And first time only I'm robbing, but I will rob the entire bank for 10 crores. Or see, 10 crores is very less. Maybe I don't know how much there will be in a bank. In my wild imagination, I don't know. Maybe 10 crores. Okay. So whether first time I have robbed the bank, give me community service, I can ask. No, I cannot ask. So theft also, first time, less than 5,000 rupees property. And the property must be recovered. Then only community service can be ordered. So misconduct by a drunken man in public and defamation. I don't know whether misconduct in public by a drunken man can give community service. It is little bit of serious what he acts. That's different. Okay. And defamation also you can give community service. So for community service, if it is asked, you have to give the definition, why it is inserted and it is not new, and all these examples. Remember this. It's one expected area. Now, coming to fine. This is the last slide. Pardon me. I think I have dragged little bit, but I think it will be worth of your time to secure good marks. Okay. So first of all, 53 and 4 of 53 IPC, 4 BNS says that fine can be a punishment. So if a fine is given, but you don't pay the fine, in default of fine, can we give extra imprisonment? Yes, that is given under section 64 IPC and 8 clause 2 of BNS. Okay, now default of fine imprisonment, whether that can be for 10 years, 20 years. Imagine the substantive, that is main imprisonment period, is 5 years. And I have given you fine of 20,000 rupees. Now you don't pay the 20,000 rupees. So for default of this fine, can I give you imprisonment for another 20 years? 20,000 you didn't pay. Each year, each 1,000, 1 year. 20 years you should be in jail. That is not reasonable, right? So only 1/4 of the punishment we can give default of fine. So if it is 4 years, maximum 1 year you can give. Okay, that limit was given in 65. Next you have 66. See, default of fine imprisonment is there. What will be the type of imprisonment? Whether it will be rigorous imprisonment or simple imprisonment? Answer is very simple. It will follow the same imprisonment awarded in the offense. So in the offense, if I have given simple imprisonment, default of fine also simple. Rigorous, then default of fine also rigorous imprisonment. That was given. And next, this is all they have given a limit. Okay. No type of imprisonment is mentioned. Then it is no imprisonment is there. Then it is simple imprisonment. Sometimes what happens, only fine will be awarded. The court will say, see, you find to be a very good person. You have done a defamation. So what I will do, no community service. You pay some 3,000 rupees as fine. But that person will not pay this 3,000 rupees. So for default of fine, you go to imprisonment. So what will be the nature of imprisonment here? Because older imprisonment, there is no imprisonment. So now new imprisonment has come for default of fine. So what imprisonment, what type? For those types, it will not be rigorous. It will be simple imprisonment. Don't worry about this. They are not going to ask. I am saying again, just we are discussing. So for 5,000, you commit default of fine. Even for community service, they can order community service but you will not go do the community service. So for default of community service also, we can give you 2 months of imprisonment. And from 5,000 to 10,000 rupees, you don't pay. 4 months of default imprisonment. And exceeding any other limit more than 10,000, that is 1 year. Maximum 1 year for default we can give. And next, if the person is in the jail for default of fine, he pays the amount. What you will do? You will release the person, right? Because he is paying the amount, you have to release the person. That was given in 68. And you have to understand, a person is in jail, given maybe given a fine of 2,000 rupees. Okay, he is not paying that 2,000 rupees. default is committed. So you are giving default of fine imprisonment for some 20 days you are giving. Okay. So he is in jail for 10 days. Now how much he must pay? He must pay some 2,000 rupees. You are giving 20 days. 10 days he is inside already. Must he pay all the 2,000 rupees? He can pay 1,000 rupees. So proportionally what we will do, how much time you have spent in jail, we will proportionally cancel the amount of fine. Okay. That was given in section 69 IPC. And finally you have enhanced punishment, which means, see, first time you fail in maths, father will take you to a separate place and say that, see beta, see, that's what my father will say. See Malati, only if you study, you will be placed somewhere. Only if you go to work, you can feed yourself. Otherwise, if you are at home, nobody is going to treat you properly. That's what he says. Nobody is going to talk to you properly. And you will be at home always. That will be your life. That's what he says. First time. Second time, if you fail, what will happen? You will get nice markings, right? So, first time offender, normally you can treat him, give a nominal punishment. But he is a repeated offender. What we must do? They will give enhanced punishment under section 75 of IPC and 13 of BNS. This enhanced punishment is very, very crucial only for judicial service. They will even ask to frame charges. So you UPSC lucky fellows have escaped. Okay, need not beat about this. So I'll once again say, whatever we have learned today, the theories of punishment, they will ask again and again. Okay. And what they will ask is, they will ask the kinds of punishment, what all punishment is there, and especially community service. And we have new type of punishment, that is imprisonment without remission. That they will ask. And they will ask death penalty. So I brought the previous year questions for discussion, but I know it's not the right time. So what I will do is, I will share the document to you. After the class, just go through the same. You will understand everything, because whatever we have covered here, that's what they are asking repeatedly. And I promise you, that's what will be there in your upcoming paper. Okay, you listen to class, take notes, do the answer writing practice, do very well in your prelims and GS. Soon become a IAS officer, any civil servant for that matter. Okay, so shall we wind up today's class and meet day after tomorrow? Okay. Today you understand the class, right? Anybody has doubt, you can let me know. Okay. So I'll take, there are no doubts. We will meet day after tomorrow. Do take the answer writing practice. Thank you so much.